Ms. Bork, you're charged with the state jail felony offense of fraudulent use or possession of identifying information from
Okay, hold up. Right out the gate, Miss Burke's staring down a state jail felony for identity fraud, and that's no small deal. In Texas, even one count can mean real prison time, not just probation. So when the judge asks if her plea is made freely and voluntarily, that's not some legal ritual. It's a safeguard, making sure she can't later claim she was pushed or pressured into it. Watch closely how she answers, because this is the moment
November 1st of 2023, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Fabrication.
It's admitted. Is there any evidence that Ms. Bork is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of fraudulent use or possession of identifying information, sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit.
Here's something most people don't realize. Once you're convicted of a felony in Texas, you lose your right to own or even touch a firearm. And that's not temporary. It's permanent. That one conviction follows you for life, casting a long shadow over everything. And the judge? She's making damn sure Miss Burke can't ever say nobody told me.
That sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kimler. All right, good luck to you, ma'am. You can go back with the bailiff. And then,
In the front, I'm sorry.
ma'am, go with the bailiff.
Look at my shirt, like,
Go with the bailiff. They'll take care of that.
She wants
I'm
her.
not telling anybody.
Go. No, you should have done that before you came up.
What do you want me to do?
I think
Go with the bailiff.
She wants her extra clothes in there.
Well, and if the bailiff might let her do that, but she should have piled it on.
She did. That too, she did.
Yes, sir. And if y'all can just sign that, and if you'll make sure and email the attachment to the clerk this afternoon.
Yes, ma'am.
Thank you.
You can call them.
Let's see, and I'm going. And we're going on the priors, correct?
Yes, ma'am.
Okay, let me,
Actually, Judge, it was indicted in state jail with priors. However, I've also filed a notice of enhancement alleging additional offenses that I believe gets it to a second degree. So in other words, it was indicted as a state jail felony enhanced to a third degree, and I filed a notice to enhance that further to a second degree.
all right, I'm printing out something so I can do. Make sure I go through, Okay. And will he waive the formal reading of the indictment?
Yes, Your Honor.
You're Leroy Smith Jr. And Mr. Smith, in cause number 25, DC.
Next up, Leroy Smith. And this guy's rap sheet? It's pure Texas-sized chaos. The prosecution's stacking up his prior convictions to jack up his sentence. See, those old crimes don't just disappear. Legally, they amplify the punishment for today's case. What started as simple criminal mischief could now put him away for up to 20 years.
CR 0052. You're charged with the state jail felony offense of criminal mischief from September 4th of 2023. The indictment alleges that you were previously convicted of the state jail felony offense of delivery of a controlled substance September 18th of 1995. And after that was final, you were convicted of delivery of a controlled substance, state jail felony, 2 cases, on January 16th of 2001. The state has also filed notice of intent to use prior convictions to enhance punishment. It alleges that you were also previously convicted of possession with intent to distribute crack cocaine and/or distribution of more than 5 grams but less than 50 grams of cocaine in the Eastern District of Texas on August 6th of 2002, and that on February 2nd of 1993 you were convicted in 2 cases of burglary of a building, which at that time was a 3rd-degree felony, I believe.
Not sure, Judge.
Anyway, and then after that was final, well, we need to know. And then burglary of a vehicle also on that date. Need to know what those levels
The
are.
burglary of a building at that time, Judge, was look at the judgment from February 2nd of 1993 was a 2nd degree.
2nd-degree felony. And so to the charge in the indictment,
For the record, that
Yes, sir.
burglary of a vehicle was a 3rd degree.
thank you, Mr. Coleman. And so to the charge of criminal mischief, how do you plea? And are all of those prior offenses true? Speak up, please. And are you entering your plea of guilty and true freely and voluntarily? And because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jackson? Do you fully understand them? And do you understand, so it looks like there's no agreement, is that correct? Or is there a cap?
There is no cap, there is no agreement.
So it looks like you are just pleading open to the court. These papers show that your attorney is asking on your behalf for a deferred probation. Mr. Coleman has requested an 8-year term in TDC. But if we go forward this way, you're leaving your punishment up to me. And I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first would be to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? I do want to make sure you understand that I can do anything in the full range of punishment, which because of those prior offenses is between 2 years and up to 20 years in prison. Do you understand? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. Mr. Jackson?
No objections.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and you understand the nature and the consequences of this plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. It'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and talk to Mr. Jackson about that, and he will present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right? We'll see you back at sentencing. Thank you.
Thank you, Judge.
And make sure you get that document emailed over for the discovery. Mr. Yabarbo, we called your case.
Now we meet Mr. Yabarbo, facing theft charges with a long, ugly history. When you hear the judge listing dates from the 80s, 90s, and 2000s, that's not nostalgia, that's pattern recognition. The message is clear, the law remembers. Every offense leaves a trail, and his past just walked back into court with him.
Earlier and you weren't here.
I'm sorry, Your Honor, I was outside, farther down, then I should have been.
Okay, all right, I'll recall those bond forfeitures.
I was actually by my, Valerie.
Well, you need to be close so that when the
My apologies.
bailiff calls your name, you can hear it.
You're right.
Okay, Mr. Yabarbo, in cause number 24, DCCR 1722, you're charged with the state jail felony offense of theft of property with previous convictions. The indictment alleges that was from April 28th of 2024. It alleges you were previously convicted of theft September 8th of 1999, January 5th of 2000, February 7th of 2000 in 2 different cases, September 27th of 2010, May 4th of 2011. It further alleges that you were convicted of burglary of a vehicle, a 3rd-degree felony, in 2 different cases, May 19th of 1986, and that after that was final, you were convicted of delivery of marijuana, a 3rd-degree felony, in 1987. 2 cases of delivery of marijuana on that same date, and that after all of that was final, you were convicted of possession of a prohibited substance in a correctional facility, a 3rd-degree felony, July 31st of 1996. What that means, sir, is that if you go to trial and you're found guilty in that case, the punishment would be enhanced to that of a 2nd-degree felony, which is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am, I do.
Give me just a second. And then in cause number 24, DCCR 2289, you're also charged with theft of property with previous convictions from September 28th of 2024. That indictment alleges all of those same prior offenses, which means if you go to trial and you're found guilty in this case, the range of punishment would also be that of a 2nd-degree felony, which has a punishment range between 2 years and up to 20 years. Do you understand?
What was the last one you just read, Your Honor? The 2024?
The indictment date on this case is from September 28th of 2024.
Then that was the latest, what was that? What was that about?
That's why you have a lawyer.
And Your Honor, for the record, the state will be filing a motion to accumulate the sentences in these, or for the sentences in these cases to run consecutively.
So, in the September 28th of 2024 case, the allegation is that you unlawfully appropriated property, to wit, medicine and sundries of the value of less than $2,500 from John Almaguer, which is the Walmart on Dallin Road, from, again, September 28th of 2024. So you're charged in 2 different cases from 2 different dates with theft of property. One from April 28th of 2024, the other from September 28th of 2024. Again, what that means in each of those cases is if you're found guilty and those prior offenses are true, the ranges of punishment are between 2 years and up to 20 years. Do you understand? And I have here on the computer a plea bargain rejection that has your signature on it in each of these cases with that of Mr. Kimmler's, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison on each of these cases that would run concurrently, which means together at the same time. I also want to make sure you understand what Mr. Coleman just said, and if you go to trial, because these are different offense dates, there is the possibility, if you're found guilty in each case, that he could ask me to stack or accumulate, run consecutively any sentences that you receive, and that would be up to me. Do you understand all of that?
Yes, ma'am, I do.
And do you want to reject those offers and have both of your cases set for trial?
Yes, ma'am, I do.
Okay, I will get them set on the trial docket. Mr. Coleman, is there any reason to believe there would be any change in that offer?
Absolutely not.
So I want to also make sure you understand that after today, I will not accept a plea offer in these cases unless there is some new information that comes to light that for some reason the attorneys don't know. And so if you change your mind later and want to enter a plea of guilty, it would be to something different than this plea agreement or just open to the court. Do you understand?
Yes, ma'am.
All right, and you want to go forward with trial?
Yes, ma'am.
Okay, I'll get your cases set on the trial docket. Stay in touch with Mr. Kimmler. He'll let you know when you need to be back and ready for trial. Will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Savoy, you're charged in that case with the third-degree felony offense of tampering or fabricating with physical evidence with the intent to impair from September 23rd of 2023. And how do you plead to that charge?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred adjudicated probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is
Your
there any
Honor,
other?
I apologize. One of those is forfeit the weapon as well as part of the plea agreement.
I don't think y'all wrote that on here, but.
Yeah, but that's fine.
And is it your understanding that also as part of that plea agreement, the weapon in that case will be forfeited to the state? Do you understand? So you won't get the gun back. Do you understand that? Okay. And if y'all just make sure, I don't know if you need a forfeiture motion, and I'll sign that order at
I'll
sentencing.
go grab it from Mr. Leroy.
Okay. Is there any evidence that Mr. Savoy is not competent?
No, Your Honor.
Okay. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing at a different date, and we'll get the probation department to do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop. All right, so again, you're Donald Owens Jr.
Yes, ma'am.
And so the motion to compel, has that been worked out?
Yes, Judge.
All right, you have all the information, discovery that you feel like is out there, correct?
Yes.
Do you need me to sign that order, or it sounds like it's been taken care of? So, Mr. Owens, in cause number 24, DCCR 1192, you're charged with a second-degree felony offense of sexual assault of a child from March 29th of 2020.
All right, this next one. It's dark. Sexual assault of a child is a second-degree felony, and you can feel the whole courtroom shift the second it's mentioned. This isn't just legal, it's moral. The tone changes. The air gets heavy. Even before sentencing, you can feel it, the weight of what's about to happen.
And what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the computer a plea bargain rejection that has your signature on it with that of Mr. Kelly's. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a cap of 10 years in prison, which means you would be leaving your punishment up to me, and if I followed the agreement, I couldn't give you more than 10 years. I could give you 10 years, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay? And everything's done, discovery, nothing, not waiting on DNA or anything like that. Okay? We'll get it set.
Everything we've asked for.
Get it set on the trial docket. Stay in touch with Mr. Kelly. He'll let you know when you need to be back and ready for trial. All right? Thank you.
Judge. Thank you, Ms.